I originally was part of the defense team in the case of the United States against Yassin Aref and Mohammed Hussein. They ended up losing the case and got 15 years in terror oath, and Yassin did, arrested. And in my opinion, looking at the evidence, I would say he was framed by the government. This was a completely innocent man. He did nothing wrong and ended up in jail as a sheer act of framing by the government. In 2007, we got together with some people from the Dr. Darfur Committee and with the Hashmi people. Is Faisal here? No. You know, what he was here. And between us, and we also had Lynn Stewart, we formed Project Salam. We actually had a conference very similar to the conference that's being done here, up at Albany Law School, and that's how Project Salam was born. And our philosophy at that time was to try to document and record all of the cases of Muslims that were being unfairly prosecuted all across the country. We set up a database, and we're going to write up these stories. If you'll see over here, we created a kind of a wall of victims of preemptive prosecution. And as you can see, if you look at it, a lot of the names that we've been mentioning here today, Siddiqui, Darfur, Lynn Stewart, Sami Al-Arian, Yassin Aref, Dukas, the rest of the Fort Dix Five, Qassam Alashi, so on. These are all names that we've been talking about. But there's a lot of them. We have about 109, I think, up there on the board. We could easily put up another 109. We can put up probably 3 or 4 or 5 more panels of this. We are not at this point able to keep up with it. These cases are coming so thick and fast. And that's sort of part of the difficulty. What we want you to understand and remember is that as compelling as Qassam Alashi's case is, as compelling as Lynn Stewart or Sami Al-Arian or Afia Siddiqui, all of these defendants have stories. All of them have loved ones. All of them were ending up in jail for things that they did not commit, based on unfair laws that criminalized thought and by unfair and illegal tactics by the government. So that's what I want to talk about, and I want to give particularly thank Professor Erlen for that really good talk before, because it allows me to cut my speech in half. What we discovered, what we tried to do at Project Salam was to create language that would allow us to talk about all these cases in common. What did they all have in common? Because they all presented facts that were quite different. And what we discovered, or what our conclusion was that the US government was essentially trying to target Muslims based on ideology in order to preemptively prosecute them and remove them so they couldn't do something in the future. After Yassin was sentenced in March 8, 2007, the government held a press conference, and they, at one point during the press conference, a reporter asked them, he said, well, actually, was Yassin a terrorist? And the reporter, the prosecutor gave this answer. And I've always treasured this answer because it was such a clear description of what the government is trying to do. The prosecutor said, did he himself actually engage in terrorist acts? Well, we didn't have the evidence of that, but he had the ideology. Our investigation concerned what he was going to do here, and in order to preempt anything else, we decided to take the action that we did, which was to bring the phony sting. The prosecutor went on to explain that his concern was not with people like Yassin, that they were reasonably sure was never going to commit a terrorist act. What they were concerned about were people that might be sympathetic to terrorism, that might cooperate with terrorism if a terrorist came along. And in order to understand this, you have to understand that the government wants you to believe that there are this sort of random bunch of terrorists that are running around out there killing people for no particular reason. In fact, that's not what happens at all. There are organizations all over the world that are doing important things. They have perfectly legitimate goals. They want to feed people and get freedom and protect their culture and so on. But they may have a paramilitary arm that engages in violence, and if they engage in violence too strongly, they end up on the designated terrorist list. And we have created laws, the material support laws, that suggest that if you say anything positive about these organizations that may be feeding the homeless or clothing the naked or doing any of these other good things, but who are on the designated terrorist list, that you will be in some way enhancing the prestige of these organizations and therefore are contributing material support to terrorism. This is what the thought law, the criminalization of thought, criminalization of ideology is all about. And that's one element, that's the first real element of preemptive prosecution, is focusing on that ideology. The second thing is targeting. What the government does is it goes out and targets individuals by massive surveillance. Now, in the old days, in the good old days, a few years ago, we had a constitution that required probable cause before search and seizure. I would say that's out the window now. I don't think anybody believes in that anymore. There is, of course, the total information awareness system, which mines all of the databases. There is massive surveillance. Mosques are bugged. Phones are tapped. I think most attorneys would agree probably if you're going to have a conference with your client, you have to assume that it's being monitored and so forth. So the government has a huge amount of information. The problem is they don't know what the significance of the information is, and they make a lot of bad judgments based on it. They simply are overwhelmed with facts and don't understand significance or context. So what happens is that they will generate lists in the FBI, and then they go out with these lists and they target these people for saying these are potential security risks. We have to preemptively prosecute them. We have to come up with a contrived crime, a fake crime, anything to get them convicted. And so, in some cases, it is sufficient to simply have violated the material support laws. And I think the Alarian case is the classic case of this. This is simply free speech, exercise of free speech about various organizations. They said that's material support, and that's what's triggered all of the legal problems that he has had. Holy Land Foundation, another case just like that. But you get other cases where people sort of talk on the internet and there's some loose talk about jihad or this or that. It gets picked up by the FBI, you get put on a list, and then the FBI has to somehow manufacture out of this information a triable case. And what they typically do is they will send in an agent provocateur to try to get to know these people, to try to push this thing over the line into criminality. And they're brilliant at it. I think perhaps the worst case I've seen is Newburgh 4, where they hired a snitch who went in there and hung out in a parking lot of a mosque and offered large amounts of money to anyone who would involve himself in jihad. And for the trouble, he got a hold of one person who was a kind of chronic liar who built himself up as a very dangerous individual, but in fact had never done any of the things that he said. And then they recruited a homeless person and a crack addict and someone with mental problems, and offering them up to, in some cases, $250,000, BMWs, and buying barbershops, whole kinds of stuff. That trial is going on right now. We are following it. It's a fascinating trial of how low the FBI will go. And I know all the lawyers are kind of nodding in the back. How low can you go? How low will the FBI go to get another bag? So certainly the Newburgh 4 is close to the bottom of the barrel.